Thank you so much, Laura. Good morning, everyone, and thanks for joining us for this session on enhancing pro bono placement through friend of the court practice. My name is Alla Holmes. As Laura mentioned, I'm a program manager with the Learning and Development team at the Acacia Center for Justice. As you may know, Acacia, like its predecessor organization, Vera Institute of Justice, works with legal service providers nationally to offer a broad range of representation orientation services to immigrant children, families, and detained adults facing removal proceedings. All of the orientation programs that we manage include a pro bono placement component, and Acacia supports our networks of legal staff in developing best practices for improving referrals, training, and case placement with pro bono attorneys. Prior to joining Vera, I spent several years training and mentoring pro bono attorneys with Kind in Los Angeles and at emergency reception centers through the ABA's CILA. So enhancing pro bono services near and dear to me. My co-presenters here to help you incorporate friend of the court services into your pro bono programs are Prathiba Desai and Emily Brock, and I'll turn it over to them for introductions now.
Hi, everyone. My name is Prathiba. I'm a Senior Program Associate on Learning and Development. Prior to joining Acacia, I worked in New York City representing mostly survivors of intimate partner violence. And I'm excited here today to share with you our presentation on friend of the court.
Hi, I'm Emily Brock, and as Laura said, I'm Deputy Managing Attorney of the Children's Program at Rocky Mountain Immigrant Advocacy Network. As part of my role, I supervise our Immigration Court Help Desk and Family Group Legal Orientation programs with the Denver Immigration Court, and have been doing friend of the court practice since I joined RMIAN in 2014 as a UC fellow, and we started using friend of the court principles for UCs, and we just sort of expanded it from there and now actively use it within our Immigration Court Help Desk and Family Group Legal Orientation programs. And so I'm excited to share just how useful this tool is. It's such a great tool. So I'm honored to be here and to talk about it.
Thank you both. I know all three of us are really eager to tell you about the secret superpowers that come along with friend of the court services. But before we jump into the details on friend of the court, we wanted to get a sense of your comfort level with this topic through a couple of polls, which you will see pop up on your screen in a moment. So we would appreciate if you could take a moment to respond to this first poll. Great. So it looks like many of you have observed others serving as friend of the court. A few of you have served as friend of the court. And about a third of you are curious to learn more. Thank you. We'll do one more quick poll. If you could put that up now. Thank you all for those responses. It sounds like friend of the court is relatively new to most of you, and you are hoping to learn more. And even those of you who have used friend of the court have not necessarily folded this tool into training for pro bono attorneys who handle cases in your area, perhaps because it's not entirely clear how your organization or the pro bono attorneys that you work with would serve in this capacity. So we've seen through our work with legal service providers nationwide that friend of the court has really been an underutilized tool, which can make a significant difference to the cases of individuals who could most benefit from pro bono representation. So we really hope that today's discussion helps increase your comfort level with friend of the court and empowers your team to incorporate the use of friend of the court into your pro bono training and placement processes. So if we could move on to the roadmap. I'll get us started with a bit of background and guidance on friend of the court before I turn it over to Emily and Prathiba to discuss the process of implementing friend of the court, common and innovative uses for friend of the court, and the benefits of incorporating friend of the court into your pro bono program. Please feel free to throw questions into the chat as they arise, and we will plan to address them during the Q&A at the end. So let's take a look at some of the EOIR guidance setting out the scope and purpose of friend of the court. While friend of the court may have been used informally in courts prior to 2014, September 2014, when the O'Leary memo came out, that was really the first time that EOIR officially permitted friend of the court in immigration proceedings in cases involving unaccompanied children. Next, we had the McHenry memo that came out in November of 2019, which expanded the use of friend of the court to adult proceedings, but continued to emphasize that the friends of the court are fundamentally an aid to the court and not an advocate. When EOIR released the most recent Neal memo in May of 22, it further expanded the scope of friend of the court services and urged judges and court staff to facilitate the use of friend of the court. If you have not already, I really encourage you to familiarize yourself with this memo, which we will include in our resources, as it's going to be a great tool to your team in easing the introduction of friend of the court at your local courts. So I wanted to touch on a few key highlights from the 2022 memo. The first change that we saw in this Neal memo was an expansion to the definition of the purpose and scope of the friend of the court role. The memo notes that friend of the court can be an individual or an organization that participates in immigration court proceedings in order to facilitate the flow of information in the courtroom. The memo also specifies that the role of friend of the court is to increase pro se respondents' understanding of the process, as well as their rights and obligations. And the memo explicitly states that it's within the ability of a friend of the court to call attention to law or facts that may be helpful to the court and to provide information to the immigration judge. The Neal memo still emphasized the same limitations. If you could flip the slide to the friend of the court as in prior memos, specifically noting that a friend of the court is not a party or a representative of a party in proceedings, and that friends of the court cannot submit filings or accept or concede service as part of their friend of the court role. And importantly, a friend of the court is never intended to be a substitute for a legal representative. So next, another notable aspect of the memo is its explicit language, we could flip, encouraging the assistant chief immigration judges to coordinate with EOIR's legal access programs to facilitate friend of the court. As you're introducing friend of the court to judges locally, we recommend incorporating this language from the memo into your initial outreach and into stakeholder meetings. The memo also builds in a lot of what are called EOIR flexibilities. Namely, it allows judges to give cases with friend of the court accompaniment priority when scheduling master calendar hearings, and to consider the creation of a separate friend of the court docket. It also allows and even encourages friend of the court to participate remotely, including using EOIR's video teleconferencing or WebEx equipment. So next, the memo provides a non-exhaustive list of examples of ways that a friend of the court could assist a respondent in court. Some of the highlights that I wanted to mention now are helping with courtroom mechanics, which could provide courtroom orientation or help explain the functions and procedures in the court. But importantly, it also includes sitting with the respondent during the hearing itself. A broad category within the memo is facilitating communication with the court, which would allow you to reinforce information provided by the judge, seek clarification from the judge when a respondent is confused, or alert the court or DHS attorney to a lack of understanding by the respondent. The broad guidance, I'm actually sorry, if you go back for a second, the broad guidance that allows a friend of the court to take steps proactively to enhance understanding between respondent and the court, which means that you can go ahead and raise relevant issues without having to wait for a judge to request information before sharing it. So I urge you to consider ways that your team can help communicate information pertinent to the respondent's case as a friend of the court. So this may include information about efforts to secure representation or your organization's services, and any other special needs that the respondent may have related to the proceedings. If relevant, you might consider bringing any mental health concerns to the court's attention, or alert the court to a particularly sensitive or discrete issue related to a respondent. And as an extension of your friend of the court role, you can also assist with certain forms like change of venue or change of address, or serve as a liaison by connecting the respondent with available community resources, including, of course, pro bono, legal, and social service providers. And friend of the court also allows you to look into other aspects of the individual's case, including asylum or adjustment of status procedures happening at CIS. So next, as you can imagine, the concept of friend of the court can be really confusing to a respondent who's hoping to find an attorney to represent them in court. So the memo emphasizes both the judge's and the friend of the court's obligation to make sure that their role as a non-representative is clear to the respondent. So specifically, the memo says that the judge should ensure on the record that the respondent understands that they're not represented and that the friend of the court is only there in a limited capacity, and should take particular care when explaining the role to children, adults with limited competence, and other vulnerable groups. And attorneys who are present in court as a friend of the court should note the ethical obligations that may apply to implied attorney-client relationships in your jurisdiction, and should take care to avoid such implication. And what this means in practice is that you'd want to articulate your role and limitations of a friend of the court on the record and make it very clear for both the court and the respondent. And your team might consider having a respondent sign a clear waiver and consent form at the beginning of services, confirming their understanding and limitations of the friend of the court role. So the final resource that I'd like to mention to you all is a recent friend of the court document, if you could flip the slide, which a frequently asked questions document regarding limited appearance requirements that was issued by EOIR this past July. And the document references friend of the court twice. It does note that the limited appearance requirements don't affect the ability of a person to appear as friend of the court, because friends of the court are, as I mentioned earlier, an aid to the court and not a practitioner. But do keep in mind that the FAQs say that if a practitioner appears in immigration court in a friend of the court capacity, but later provides document assistance to a pro se respondent, they will be required to complete the EOIR 60 or 61 form. So before I turn it over to Emily, I did want to work through one quick hypo, if you could flip to that on the next slide. So I will go ahead and read it aloud, and then we'll put up the question as a poll. You are present in immigration court when you receive a message from a colleague about Miss Ming, an individual that they met during an information session as part of their immigration court help desk services. Miss Ming called your organization because she has a master calendar hearing and will be delayed getting to court because of a health emergency. You agree to appear as friend of the court to notify the judge that Miss Ming is unable to attend the hearing that morning, but that they have individual information sessions scheduled with your organization next week. The judge agrees to a continuance and sets a new date for the next master calendar hearing. The judge calls you up to accept the new hearing date notice and asks you to give Miss Ming a copy at your next meeting. If we could go ahead and have the poll now. Please let us know. Are you able to accept service of the new hearing notice on behalf of Miss Ming?
You should be able to see them. Sorry, we might be having a tech issue on our end. But I can tell you what they are. Everyone, 100%, everyone said B.
Great. Well, it sounds like everyone was paying attention. Thank you all for those responses. And yes, that's right. You cannot accept service on behalf of Miss Ming because she's not your client and you're not her representative. You are just there as friend of the court. But it's, we also understand that it's easy to get flustered when a judge is telling you directly or asking you to do something on behalf of a respondent. To have to take a step back and explain the limitations on your capacity as friend of the court may be challenging, but we really encourage you to use that 2022 EOIR memo to point the judge to the section indicating the limitations on friend of the court, and to explain that Ms. Ming should be served with the hearing notice the same way that she would be if the friend of the court was not there, because the friend of the court is not the attorney of record on the case. So thank you all. With that, I will turn it over to Emily to talk about implementation of friend of the court.
Well, and I think that's a great transition, right, from that concept of is the judge confused about the role of the friend of the court, and like how do you jump into a friend of the court practice when maybe your judges don't know about it or you've never tried it with your organization. So in order to start off our section on implementation, we have a quick poll about your sense for those who have served as friend of the court, what the sense within the judicial community is in your jurisdiction. So if we can put that poll up. Okay, those results sounds like in a lot of jurisdictions, or I don't know, maybe we're all concentrated in similar jurisdictions, but it sounds like those with experience find that friend of the court is over 50% welcome in courtrooms, and those that where there is where friend of the court practices are not welcome, perhaps a lot of it is confusion versus an active resistance to the practice, which I think is fairly common because it's sort of outside the scope of a regular legal practice, right? Like you're either someone's attorney or you aren't generally in the legal practice. So I think if we go to the next slide, I think the initial outreach methods and building your stakeholder relationships are what's key if you're going to try to implement a friend of the court practice or a friend of the court program within your pro bono practice. We certainly at RMIAN have always requested, not always been granted, but we have requested stakeholder meetings through the years in order to kind of have a common understanding of what front of the court practice might look like from RMIAN. And so that's a good, if you can get a stakeholder meeting where all of the judges attend, that's a good way to kind of have a group understanding of what services you're going to provide and how your staff members might be appearing as front of the court. Additionally, or alternatively, so it might be a good idea to have a senior staff member, in our case, it's always been sort of the senior attorney in the program, attend master calendar hearing settings and for each of the judges, and at the end of that setting, approach each judge about front of the court services. And that's especially true if you haven't had that group stakeholder meeting where all of the judges are present. And we also regularly check in with the judges, either through those stakeholder meetings and or by quarterly attending master calendar hearing settings, separate and apart from settings where we are actually going to appear as front of the court, just to say, hi, Judge, how are things going? Is there any confusion on our services? Is there any way that we can be more helpful or more clear on when we're front of the court or versus appearing as attorney of record? And I can't stress this last one enough. Make friends with the clerks. Like the clerks are the ones who are going to really kind of explain to the judges, no, they're helpful, or no, this is a friend of the court, they should go first, right? In our court, friend of the court gets to go first because there's an understanding that it's from a nonprofit organization and we've got a heck of a lot of things we've got to get done by the end of the day. And so they put us first so that we can also go and provide other services to individuals, such as screening an individual. We might be coming forward as front of the court on saying, hey, Your Honor, we're here to provide a consult for this child. So again, communication, I think through that initial outreach is really important. And, you know, Alla has talked about the memo multiple times in her presentation, but I always have the memo on me, whether it's like when I'm talking to a new judge or even a judge who has seen me for many years. It's always useful to have that memo in the event that you have an OPLA attorney who objects to you appearing as friend of the court, or the judge themselves is objecting to your appearance as friend of the court. And I think it's all about communicating this sort of outlined permission to appear as friend of the court, because then it gives the judges sort of the sense that, oh, okay, I can let this happen. I can allow this to happen. We can go to the next slide. That doesn't mean that all the judges are open to it, whether it's because they're confused by it or because they see it as an impediment to the operation of their court, or they don't want people appearing as friend of the court. But I always try to take a step back and ask myself, okay, where does the disinterest come from? Does it come from a lack of understanding, in which case, oh, here's my memo, Your Honor. Like, and I bring multiple copies, and all of my team have multiple copies of the memo with them so that they can provide that copy and say, here, Your Honor, here's a copy of the memo on friend of the court practice, so that they have it right there in front of them. They can't say, oh, I'll look at it later, right? No, here it is. I've got it right here. And sometimes they just haven't had experience with it, right? So they see it as, oh, here's this attorney coming in, or this paralegal or legal assistant coming in and trying to slow down my proceedings, right? I've got 60 respondents on my docket. Let me just get through this docket. I don't need to hear anymore. And I think that the more that you appear as friend of the court, and the more that you can sort of show the judge, well, actually, Your Honor, if I appear as friend of the court, I can actually like help get that notice to the person who's sitting right there. I'm not saying receive service, like, or accept service or effectuate service, but you can be the one that, so that, you know, it's not the respondent that's trying to approach the bench and maybe taking longer than you might take to get that notice to them. I can, you know, bring up the 589 to the judge that they have completed themselves. You had nothing to do with it. It's just literally facilitating the handing over of the document to the judge, and just seeing the mutual benefit of having someone who speaks the language of the court, that understands what's happening within the court, and can act almost like an interpreter between the respondent and the judge, right? And I think the other thing that you have to think about when you're receiving pushback, you know, I think something I've noticed within my team, the people who haven't done it very often, is this sense of like, oh gosh, if the judge is pushing back, I should probably just not appear as friend of the court. It's fine. Like, I'm just going to let it go. Think to yourself, will the individual benefit more from you stepping back, or more from you stepping forward and saying, no, actually, Your Honor, I can do this. And by the way, this kid is SIJS eligible, so please don't force them to go forward on an asylum case. Or please don't order them removed because they can't articulate the fact that they are eligible for SIJS, and so you think that they don't have any relief. Or please understand that there is a police report because this child was the victim of a crime. And I'm using children as an example because it's a common, you know, it's a more common use of friend of the court, and I think more accepted, but you can use it in the adult context. We've used it to consolidate kids with their parents, right? These are the types of ways that you can really benefit or provide a benefit to an individual who's in removal proceedings. And then you can consider, do I need to elevate this issue, right? You can elevate a repeated lack of permission to go as friend of the court to the ACIJ or to the Office of Legal Access Programs. Like, they want to hear about this, right? The memo specifically directs judges to facilitate the use of friend of the court services. So they should be facilitating it rather than pushing you out. You can also think about ways to, if you have a judge that won't let you appear on the record, go to OPLA, try OPLA. The OPLA attorney's there. You know, we had a judge that refused to let me go forward to explain that a child had tried to get on a plane to come back to Denver for his master calendar hearing, and the flight was canceled, so he didn't end up getting to Denver, and he would not let me go forward to explain that. So I went to the OPLA attorney and I said, you know, counsel, as an officer of the court, I can show you the text message from the family member. The flight was canceled. You can see that Frontier flight number, you know, whatever the flight number was actually canceled. You as an officer of the court are required to convey to the court that there is information that the respondent tried to attend, and that there's a reason why he's not here outside of his control. So OPLA went forward and said, we're not asking you to proceed in absentia today, Your Honor. So these are sort of creative ways that you can, while you're thinking about how you communicate the benefits to that judge and convince that judge to allow front of the court services, still act as front of the court, just not directly with the judge. If we can go to the next slide. Okay, staffing models for front of the court. This is always, I mean, all of us who are in nonprofits, staffing is like the thorn in our side, right? It's the thorn in our side that never gets solved. And it's always like, where do I send people? How do I allocate resources? And so, you know, I'm giving these as general guidelines as to the way we've found is most effective, but that doesn't mean that your organization should step away from front of the court if you don't have multiple attorneys, or if you don't have an attorney in the pro bono coordinating role, or, you know, whatever it is. And it doesn't always have to be the pro bono coordinating attorney who's coming forward as front of the court on these pro bono, on cases that are kind of connected to your pro bono program. If you are an organization that has, you know, kind of a legal orientation program, either the Immigration Court Help Desk or Family Group Legal Orientation Program like we do, or some other version of that that's not officially, that doesn't officially go through EOIR, you know, you can use those attorneys as well. But generally we we say that the best practice on the record, if a friend of the court is going to proceed as on the record, generally it's best practice to have an attorney conveying legal information, right? It's not that non-attorneys are precluded, an attorney or DOJ accredited rep. It's not that non-attorneys or DOJ accredited reps are precluded from conveying legal information, right? That's not unauthorized practice of law. It's just a little sticky, right? So you want to avoid that, and you want to avoid the judge saying, wait a second, why is this person who's not an attorney coming before me telling me that this child might be eligible for legal relief? But non-attorneys can easily convey life information, right? The example of Ms. Ming in the previous hypo, like, you don't need to be an attorney to show up and say, Your Honor, we have information that this individual is going to be late to court, right? That is not legal information. That could include health concerns, events, other events impacting timely attendance, a change of address, right? The fact that the respondent no longer lives in the jurisdiction and tried to file a change of venue or what have you. And then complicated scenarios regarding pro bono matches, assignments, or issues, I think are best conveyed by attorneys, but can be conveyed by non-attorneys as well. Assistance completing paperwork. Assistance with EOIR 33s and change of venue are easily handled by non-attorneys, since it's like essentially data entry into a form, and that would not require an EOIR 61 or 60. Mere translation of other relief forms, such as a 589, can be completed by a non-attorney, but they absolutely should not be answering any questions about how to complete the form, right? And then drafting letters regarding possible pro bono matches can easily be done by non-attorneys. And we've provided a sample letter that we've used in the past. And you know, that's another way to save on staffing, is if you don't have someone who can appear on the record, you can provide a letter, right? Like give the letter to the respondent to convey to the court. Next slide, please. Okay. So I think I'm behind on time, but there's a hypothetical here, and I'll read it and then we can put up the poll. You are a new nonprofit that's relying on referring the majority of your intakes to attorneys in the community that do not have experience in the practice of immigration law. Your grants limit you to one attorney and one legal assistant. There is a backlog of cases that need to be referred, but many of those cases are currently scheduled for upcoming master calendar hearings, and you do not have time to pull together referral materials for all the cases before their hearings. What do you do? And then you can look at these options and let us know what you would do.
So I'm not sure if everyone's able to see the results, but we've got 83% that chose attend the master calendar hearings as friend of the court, number C, or letter C, and we've got 17% that chose B, tell the clients they need to explain the situation to the judge.
So I think either option is perfectly fine, right? Especially if what you're going to do is provide a letter, you know, expressing the fact that they've been matched. But I do think that certainly in our jurisdiction, it goes a long way to appear as friend of the court. And since the memo specifically pushes judges to facilitate or allow for internet-based appearance, that might be a good option, which is to just appear via WebEx if that's possible. Okay, and I think I will hand it off. Oh, written communication, sorry. In all communication, you should always make it clear that you are appearing as friend of the court. I think Alla already spoke about, you know, identifying yourself on the record, but also within your written communications, to the extent possible, you should make that clear, and addressing any letters that come from your organization to the individual to make it clear that, and make it clear that they have permission to share it with the court, makes it clear that you're not actually moving the court for a continuance, for example, that you are just conveying to the client, to the individual, that they are being matched with a pro bono attorney. And these are the sample letters that we're providing as part of our materials. So you certainly are welcome to use them. Next slide. Okay, and now I'll hand it off to Prathiba for common uses of friend of the court.
Thanks, Emily. Okay, everyone. So I'm just going to cover some ways that the orientation programs that we work with at Acacia have used friend of the court, and explore like how they can be incorporated into pro bono offerings as well. So these are this is just a brief overview of the orientation programs under EOIR's legal access programs. The legal orientation program works with adult individuals in DHS, ICE detention facilities. The Immigration Court Help Desk works with non-detained respondents and aims to increase efficiencies in proceedings. The legal orientation program for custodians provides legal orientation presentations to adult caregivers or custodians of unaccompanied children in EOIR removal proceedings. And then last, the family group legal orientation program that provides families placed on the dedicated dockets with information about practices and court procedures. So these are the programs that we're going to pull some of the common uses of friend of the court from. Okay, so let's talk in more detail about some of these uses of friend of the court. The first is assisting respondents to understand the process. And you can speak with respondents before and after proceedings to conduct many screenings, answer any questions about the court proceedings or court process. And personally, I think this is a huge value of friend of the court, because the court process or the immigration removal process is extremely daunting and intimidating. I remember when I first appeared in court, it was more nerve-wracking about where to go or understanding where people sit in the courtroom. And I think this is a huge value to explaining the process and what people can expect in the courtroom. Next is Emily and Alla kind of have discussed some of these already, but assisting with change of venue. And this assistance is also really important because oftentimes respondents have moved or planning to move, and properly getting venue change can make a difference in them receiving an in absentia order or missing a court date just for lack of understanding of what types of motions need to be filed. Requesting an appropriate interpreter also super important, because many times respondents who speak a third language, indigenous language, but understand enough for example, Spanish to work with an interpreter in the court, maybe don't want to speak up and request an interpreter because they're nervous, they don't want to delay the proceedings. So having somebody appear and advocate to request an interpreter is crucial for them to understand what's going on in their proceedings. Emily touched on this also, obtaining continuances. I think this is really important because the friend of the court can step in and give updates about finding an attorney, pro bono placements that may be in the works of giving this update to the court. And also explaining collateral relief or identifying important documents. So if during a mini screening quickly you're looking through the respondent's papers and you notice a police report where they're named as a victim, you can flag this potential collateral relief for U visa eligibility, for example, and allow the respondent more time to find legal representation or pro bono placement. Also similarly, flagging medical or safety concerns. This is hugely important to improve the efficiency of the court process because, for example, if the next court date you happen to know that the respondent is pregnant or will likely miss the next court date, you can flag this for the court to bring that important information. And then last, third-party notifications, TPNs, for respondents who suffer from serious mental illness, and bringing that information to the court as well. And then we're gonna do our third hypo. I'll just read it out for everyone. You're working in the pro bono room as a part of the legal orientation program for custodians team at your local court, and you receive a call from Camilla, a sponsor of an unaccompanied child, asking for an intake. During that intake, you enter the file number into the automated case system and discover that the child, Sam, is scheduled for a master calendar hearing tomorrow. Camilla informs you that Sam is now residing out of state and requiring medical treatment stemming from a work injury. Camilla also explains that Sam was injured due to dangerous work conditions stemming from exploitation at his place of work. What type of friend of the court services would Sam benefit from? 1, assist with change of venue. 2, flagging medical or safety concerns. 3, request an appropriate interpreter. 4, explain collateral relief. Or 5, identify important documentation.
All right, so I'm not sure who can see the results, so I'll read them out loud again. So we have 9% picked option A, which is 1 and 4. 45% picked option B, which was 1, 2, and 3. 18% picked option C, 1, 2, and 5, and 27% picked D, which is all of them.
Okay, so I can just go through them really quickly. The correct answer was B, but depending on additional facts, I think all of the above, all of the choices would be useful friend of the court services. So depending on facts, additional facts like unique language needs, or if there were any previously filed police reports or documentation regarding the workplace injury, I think D could also be an answer. But we know that Sam is out of state due to requiring medical treatment. It's unclear how long they're going to be out, so assisting with the change of venue would be helpful. Flagging the medical or safety medical concerns. There's nothing in the facts that indicate requiring an interpreter. You may also want to explain potentially that there's a workplace exploitation situation going on, but just flag that. And apart from that, you don't really have any documentation, right, like that you have seen. So, but with additional facts such as a police report or something like that, then you might have that as well. But yeah, so these are all ways that Friends of the Court services have been used in our programs, and we've seen many examples of the benefits of having a friend of the court available to respondents. And now I'll just pass it back to Emily.
So now we're sort of gonna sum up with almost a summary of the benefits of incorporating friend of the court into pro bono programs. I think, what's clear in our presentation is that, this whole presentation is about this whole symposium is about increasing capacity for pro bono programs and practices that will help pro bono programs. And nonprofits are always struggling to have sufficient resources, and friend of the court services is a way to expand your ability to help more people while not entering your appearance or not having to have an attorney on staff necessarily, right? It also builds relationships with the court. And we'll go to the next slide. I think, additionally, when you're referring cases to practitioners who are not familiar with the practice of immigration law, which I certainly within RMIAN, that's a huge component of our pro bono referral process, is to, corporate lawyers and tax attorneys and all these lawyers in the community that want to help and want to do something meaningful, but have absolutely no understanding of immigration law. So to pass a case that maybe you've got, mom and one child docketed on one docket and a child that entered separately in as a UC on another docket, you're not going to be like, okay, well, here's a motion to consolidate, and here's this, and here's how you make these arguments. That's more complicated, right? So if I can go as friend of the court on that UC kid's docket on their master calendar hearing and just ask the judge to consolidate it, I've reduced what that pro bono has to do by one thing. And so it's a cleaner case. It's a much more straightforward case to refer to a pro bono, which I think reduces the amount of cases that come back to you, right? I think the more complicated the case is, the more likely it is that it's going to get returned to you saying, I don't know what I'm doing here, I need help, and passing it back. We also see a better stakeholder relationship with EOIR, right? Like, when you are in the courtroom and you are helping to facilitate information, the exchange of information between respondents and the court, they start to see that their courtrooms are moving a lot more efficiently, or there are more cases that might have relief explained more explicitly to them. And so it creates this better relationship, including setting up a better relationship for your pro bono attorneys, right? If you are showing up in court and saying, look, we've got these pro bono attorneys, but they're not from the practice of immigration law, so it's taking a while to refer it. So, just bear with us, Your Honor. When that pro bono shows up in court and doesn't necessarily know that you have to print this is how old I am, right? That you have to print the EOIR 28 on green paper, right? We had pro bonos always showing up in white paper, and the judge is rolling their eyes, and it's like, well, Your Honor, they don't know. They're not normally in this courtroom, or they're not normally in this practice. Or it's also helpful to have pro bono attorneys come and observe, come and act as friend of the court. You know, you can have them come at the same day. I have attorneys come on days when I'm there all the time, and I'll sort of go, okay, you try this time. Have fun. And it gets them sort of the experience of appearing before a judge before they're actually on their own case. So the feelings of the sense of the legal responsibility are just a little bit less. And the you know, if it's on a change of address, that's easily fixed if a mistake is made, right? Let's see, requesting continuances. I don't know about you all, but our program, when we get slammed, it's like, we can't get these referral materials out fast enough, and oh crap, sorry for the use of the language, there's a hearing, you know, 2 days from now, and this pro bono can't appear on that docket. And I mean, I'm not going to enter on all these cases. I already have 87 cases of my own. I don't need pro bono cases on my ECAS system as well. And so being able to go and just say, Your Honor, look, next time this respondent appears in court, they will have an attorney with them that's matched through our program. I can't move this court for a continuance because I am not the legal representative, but I will say that they will have counsel if this court were to grant a continuance, right? There's all sorts of creative ways that you can say these things and get continuances for people. And Denver court, if you ask for a continuance, I'm getting a continuance in 2024. Great, right? Language access, you know, pro bonos aren't necessarily going to know about the breadth of languages that appear in immigration court, right? There are all sorts of indigenous languages, and you might flag it in a memo to them, but they won't necessarily know to flag it for the court. So if you've already flagged it for the court, that's one less thing the pro bono has to think about when they're appearing as the attorney of record. And then recommending safeguards. Again, we see respondents way more often than any of our pro bono attorneys, right? We encounter people, we're doing the intakes, we're doing the consults, we're hearing the stories, and we are learning through our experience when we need to flag that a safeguard needs to be put in place much faster than a pro bono might, right? This is a population, a vulnerable population that we work with regularly and are able to identify the issues that these kids or adults or families are facing. And so again, it's just another thing that a pro bono doesn't have to think about, doesn't have to know about, doesn't have to factor into their legal analysis. Because again, most attorneys who are outside of the practice of immigration law are not also social workers like we are, right? They don't know to find out about the context of someone's life and how that might impact their ability to tell a judge or tell their attorney the worst things that have ever happened to them in their lives. So again, this is just another benefit to using that friend of the court service. Yeah, I mean, there are all sorts of benefits. I could go on and on. I do want to take a pause and see if there are any questions. Because we did kind of convey a whole lot of information, but I can also just keep talking. That's also okay too.
Thank you so much, Emily. It's so incredibly helpful to hear how friend of the court fits into your day-to-day practice and into the pro bono program at RMIAN. We will open it up for questions in a moment. I just wanted to note that in our materials and listed on the last slide in our PowerPoint, we have the May 2022 friend of the court memo, as well as EOIR's latest FAQs on limited appearance requirements. And we've included a number of samples and templates, which we hope will help you increase the use of friend of the court at your local courts. So with that, we can go ahead and open it up for questions in the chat. Or as Emily mentioned, we have additional hypos or, you know, sort of scenarios we could talk through if there are no questions.
Well, I'll kind of jump in with a scenario that we kind of encountered recently. Unfortunately, we had a pro bono who was a rock star pro bono, just was really had pulled together the case, was waiting in the merits queue for an asylum merits, all ready to go, and had a family tragedy, and is not able, I mean, this poor woman she's closing her immigration practice. It's just closing her practice and not proceeding anymore. And we don't have another pro bono just waiting in the wings, right? We've got to recruit somebody for this case. And so, she had a master calendar hearing to set the merits scheduled. And rather than have one of us enter, right, where we could get stuck and on the hook for an asylum merits that none of us have the capacity for at this time, we were able to appear as front of the court, and she didn't even have to come and just say, like, look, Your Honor, there's been this tragedy in this attorney's life. Like, can you, would you be willing to allow this respondent to seek a continuance in order to allow us to re-refer the case in its current state? And all of the things that I just talked about came into play, right? We have credibility with EOIR, because when we come as front of the court and we say that this respondent is going to be matched to a pro bono attorney, at the next hearing, that kid or that family or that adult has a pro bono attorney. So there's just sort of this regular sense that our word means something, and that we're not just kind of playing games. We also didn't have to enter our appearance. I did not have to enter my appearance and get stuck on an asylum merits that I don't do asylum merits anymore. I don't have time for them. So I was able to just get our pro bono coordinating attorney more time to re-refer the case and get another attorney on board. And then the respondent didn't have to go to court by themselves and ask that the attorney be withdrawn and that they please be allowed to find another attorney, right? They had someone sitting by their side, sitting at the table with them, saying, this is the situation, and explaining it in words that the judge could hear, right, and could understand, as opposed to trying while shaking and being overwhelmed by this sense that their attorney can no longer help them and try to talk to the judge at the same time. So these are all the things that come into, one situation, which is why front of the court is just so beneficial, because you're doing all of these things at the same time. So that's another example. Apparently we're just super clear. Nobody has any questions. Either that or it's early and people need more coffee. I'm not sure. It's early in Denver, so.
Hey, I've got a question for my JP. We recently got an email sent around about the various judges and what their policies are going to be about allowing for remote representation. Luckily, none of our judges here in San Diego are going to require a motion to appear by telephone at a master. Mm-hmm. But we expect that this trend is going to go towards more in-person appearance. What are you guys seeing, I guess, across the rest of the country, and the appetite for pro bono rep if they're requiring more and more in-person appearance?
So I think, we were able to recruit pro bonos across the nation for cases in Denver because of internet-based appearances, and even just even within private practice, right? You can increase your capacity if you don't have to sit in court for an entire master calendar setting, waiting for your client's case. I do think we still are recruiting pro bonos, and we're still recruiting pro bonos that I think are younger and want more court experience, right? They want to get experience. They might be at a big firm where they won't actually be the lead litigator for years. And so if they accept a pro bono case, they're able to be lead litigator on that case because it's a pro bono case and there's no senior attorney that's taking over. But I do think it's an issue. And I think that we have used the memo to kind of support the principle that our pro bono should still be allowed to appear on WebEx or by phone. And it's worked.
Okay, great. And then are you seeing, like, we at IJP are not using pro bonos or volunteers of our organization to do friend of court, maybe because we have orientation programs that we staff at court anyway, but are you seeing an ability for volunteers and pro bonos outside of the nonprofit itself who are appearing as friend of court with the nonprofit, like associated with the nonprofit? Are they able to appear by WebEx or remotely?
You know, I don't know, because we also have a legal orientation. It's my team that appears as friend of the court. So it's, and our local bar, like nobody really has even tried it, I think. They because they know that Remain will be there. We're there every day. So I don't know. Alla, do you know at any other sites or?
Well, I would just say, given the broad nature of the definition of friend of the court, I don't see the memo applying any differently to external volunteers and friends of the court as it would to any of our nonprofit staff. So I would say, as long as you're providing the guidance and supervision to folks externally who are volunteering for you to be able to stand up as friend of the court, I think the court should, respect that and should allow either in-person or WebEx appearances for them as well.
Thanks,
Yeah, and
Al.
I would say just like make sure that your volunteers, start with, it always sounds so strange and like this big proclamation, but like, saying like, my name is Emily Brock. I'm a volunteer attorney for Rocky Mountain Immigrant Advocacy Network, and I'm appearing pro bono on this case. Like just lay it out right up front. Because I think that like, either they're still going to be snarky about it, but you've put it up front and it's on the record, or they're going to be like, oh, pro bono, great, thanks. Those are the two reactions, I think.
Yeah, those are the two reactions we get to the normal staff.
Oh yeah, I mean, it's definitely judge court dependent, right?
Yeah, specific.
Yeah. But that I think is why big stakeholder meetings, like if you can, like one of the approaches that we took in our court is that I focused our friend of the court practice and our services in the ACIJ's courtroom, because I said, if I can convince him that this is the most useful, tool he can allow in his courtrooms, and I can show him just what we are able to do and how we can help him and respondents, then I can ask for a stakeholder meeting that he can require the judges to attend. And then it sort of becomes this general practice from the top down. So that's sort of like the approach I took, and it seems to be working. We have pretty much most of our judges, with the exception of one, that actually welcome it and maybe push the boundaries of what our services can do.